SP 76343 on behalf of Mr. Waddle. President, would you say your name, sir?
John O'Dell.
This case dives straight into high-stakes courtroom drama. We've got Judge Simpson presiding, a defendant accused of skirting the edges of a no-contact order, and prosecutors determined to prove he's crossed the line. But here's the twist. What looks like an innocent act, sending blankets to his kids, quickly unravels into a much bigger problem. Was it a thoughtful fatherly gesture, or a calculated attempt to bypass a court order and reach the victim? That's the battle you're about to witness. Stay locked in, because the judge isn't buying surface-level excuses, and every slip of the tongue from the defendant digs him deeper. By the end, you'll be questioning not just his motives, but how far good intentions can stretch when the law is crystal clear. And trust me, the explanations you'll hear, they'll leave you shaking your head.
All right, what are we doing?
Judge, I think we're going to try to set this for a preliminary examination.
Discovery is complete,
Yes.
and would the people have their witnesses available the 5th?
Judge, I'm not available the 5th, so I was going to ask for the 19th.
Yeah, what happens to people when they ask for dates? Mr. Bellinger? Never mind. Will that be acceptable to the people? The 19th. Preliminary examination will be set November 19th, 2024, 9 a.m. That is before Judge Barr.
Your Honor, there are some issues regarding bond that I do hope to address with the court.
Yes.
And I was made aware of them earlier today, Judge, just so you're aware.
It's come to my attention, Your Honor, that the defendant has, in my opinion, been violating the no contact order. I understand the court might perceive it as towing the line. However, he has sent a package with a note to the victim's residence. It's my understanding that the defendant characterized this as sending it to the kids. However, the note in it said, "I love you all so much. Love someone who loves you more than you could possibly know," or something along those lines. And then there's the additional incident of the defendant at least once being seen driving past the soccer fields while the child in common was in practice, after I believe the court explicitly stated that he was not to be at sporting events while the victim was present.
The prosecutor wastes no time laying out damning claims, driving by the soccer field, sending packages with "I love you" notes, classic no-contact violations. Notice how the language here is key. The law doesn't only punish direct confrontation, it punishes any contact or attempt that could unsettle or intimidate the victim. Even the act of driving by a place where the victim is present can count. For the audience, this is a reminder that restraining orders are not casual suggestions, they're strict legal boundaries. And here's a question for you. Do you think driving past the child's practice was truly an accident, or was it a calculated risk disguised as coincidence? Drop your take in the comments, because this gray area, intention versus coincidence, is exactly where cases like this live or die.
So I am concerned at this point. This does seem to be, in my opinion, multiple violations of the no contact order. And I wanted to raise it.
Judge, he did send a package to his kids, which was just blankets for his kids and a note directed to his kids. Granted, the package was addressed to the complaining witness, but
Excuse me?
the package was addressed to the complaining witness, but it was just for the kids. He sent blankets to the kids. And then as to the,
When was that?
I don't,
Your Honor, it was ordered, I believe, on the 19th, but I do also want to put on the record that the victim moved and the defendant had to go to great lengths to find out where they relocated to. So that is another reason I'm concerned. She did not share her new location with the defendant. She did not want him to know where she lived.
The 19th, you said?
Let me confirm one moment, Your Honor. Ordered October 16th.
What was ordered October?
That was when the package was ordered.
Gotcha. How old is the child?
There's 3 children, Judge. How old are your kids?
7, 8, and 9.
7, 8, and 9.
3 kids, ages 7, 8, and 9. The moment you hear that, the emotional weight of this case hits harder. It's not just about 2 adults clashing, it's about children caught in the middle of legal warfare. The defendant claims he's just trying to send blankets, but think about the delivery method addressed directly to the victim, not the kids. That choice undermines his whole defense. Courts pay attention to detail, because details reveal intent. If you truly only wanted to reach your kids, why not involve a neutral third party? Why not use a supervised visitation channel? These omissions cast doubt on his story. And here's where Judge Simpson sharpens in. Was this about caring for the kids, or about keeping a tether to the victim? That's the million-dollar question hovering over this courtroom.
So why was the package addressed to, well, a couple things. What was the purpose of this?
Just to send something to my kids because I'm not able to contact them. And it's just something I knew that they would enjoy.
So
I was told that I wasn't able to contact her, and I was trying to abide by that and just send it to my kids. I addressed it to her, not.
why did you address it to her?
It was just something that crossed my mind because it came up as that address. I didn't mean to.
What do you mean if it came? I don't know what that means.
I didn't mean to address it to her. I meant to address it to them. I just didn't think of that part of it.
Excuse me? You
I was trying to send my
meant to address it,
to my children.
Corporal. You what?
This is where the excuses start piling up, and frankly, they sound shaky. The defendant claims he didn't mean to address the package to the victim, that it just came up. Think about that for a second. In legal terms, credibility is everything. When your explanation is vague and muddled, judges notice, and Judge Simpson notices. Notice how he presses, "What do you mean it just came up?" That's the kind of probing that exposes weak lies. And let's not ignore the fact that the victim had deliberately moved without sharing her address. The defendant accidentally found it through utility records. That stretches coincidence into obsession. Would you consider this a father going too far out of desperation, or someone blatantly ignoring court orders? Comment below, because in family law, motive versus manipulation is the thin line every judge weighs.
He meant to send the package to his children.
So why weren't their names on the package?
Because it was meant as a surprise, because they all had different blankets that they enjoy. And I couldn't leave it blank. I was just trying to send something to my kids. I wasn't trying to disobey any rules. And this is all new to me. I haven't done this before, and I was just trying to send something to my kids.
Okay. How'd you find their address?
So when I was able to move back into my house, the power was off. So we have a list of accounts that we have at our house. And so I got onto DTE to turn it back on. And that's when I saw her address, because the account was used. She used the same account. So I paid that off, and then it was said that I had to create my own account. So I logged off and created my own account. But her address was on there when I logged in. So I paid that bill and then logged off and created my own account.
So prior to doing that, you didn't know where your kids were.
I did not. I didn't do it to find them. I had to turn the power back on my house, and I went to where I knew I had to go.
And so once you see that,
Yes,
then you decide to send the package?
to my kids, yes.
But Your Honor, there were 4 blankets sent and he has 3 kids. So I don't really understand where that's going either.
Worse. All right, I'll ask the $1 million question. You have 3 kids, you're sending them a blanket. Why'd you send 4? Please, you know what?
I don't,
Think about your answer to me. I look stupid, but I'm really not.
it's just all what we used to do at our house when we lived together. They all have their own blankets and there's an extra one that they use. My son wets the bed a lot.
Oh, hold it. So
Yeah.
what you're telling me is you sent 3 blankets, 1 for each of the kids and then an extra.
Yes, because my son wets the bed a lot, so he needs an extra one.
You gotta be kidding me. Is that your story?
That's what
You're gonna tell me.
I don't know what else to tell you. I wasn't to my wife.
Well, the truth would be okay.
That's all I have.
Why'd you send, I'm gonna give you another shot. Why'd you send 4 blankets?
This is one of the most dramatic pivots in the hearing. Judge Simpson asks the $1 million question, why 4 blankets for 3 kids? The defendant stumbles into a bizarre explanation about bedwetting and needing an extra blanket. Let's pause here. In a courtroom, over-explaining can sink you. Instead of sticking to a clean defense, he spins a story that sounds rehearsed and worse, unbelievable. This is where jurists, judges, and the public tune out credibility. Simpson even cuts him off. The truth would be okay. That line lands like a gavel strike. It signals the judge isn't convinced and doesn't appreciate being misled. For the audience, ask yourself, does this sound like the truth or a desperate cover? Because in law, once the judge smells dishonesty, every other word you say gets doubted.
That's what I have because that's what we do at home. That's what we did before. That's how I know what she's done because she's told me. Because my son's extra blanket is actually on the bed at my house right now. Like she made the bed when she left and it's still there.
Okay, what about driving past sporting events that she's at?
It's my understanding, but I'll let him explain it.
No, go ahead, Counselor.
He was driving his work truck from work to a auto parts store.
Now the defense tries to spin the soccer field incident. They say the defendant was just driving his work truck, heading to an auto parts store. Sounds convenient, doesn't it? But here's the catch. Even if true, the law looks at perception as much as intent. If the victim or kids see him driving by, it can be interpreted as intimidation or harassment. Judges aren't only protecting direct safety, they're protecting peace of mind. And notice how vague his own attorney is here, relying on, I don't think he stopped, and I don't believe he even knew. That's not a strong denial. In court, uncertainty doesn't help your case. Audience, weigh in. Do you believe this was an innocent route to AutoZone, or do you think the defendant was testing the limits of the order?
In the same city and then drove back to work right after that. So I don't think he stopped or drove by slow. I think he just happened to be, and I don't think he even knew, he told me earlier today he didn't know, he knew the kids had practice, but he thought they were not at practice.
Just so I'm clear, you address the package to the alleged victim in this case, have 3 kids, so you know that there are 4 people that are in that house. You sent 4 blankets, but are telling me they were all for your kids.
Yes.
I miss anything?
No.
Counsel, do you want a hearing on this? As to a bond violation?
I mean, I guess maybe, do you know were the 2 of the blankets the same or? If you know, I don't know if you know or not. I don't know.
I don't, personally, it doesn't make a difference to me. There's 4 blankets, 3 kids, 4 people in the house. Package is addressed to the victim. That doesn't make a difference.
This is the turning point where Judge Simpson lays it bare. 4 blankets, 4 people in the house. Addressed to the victim. He doesn't need a jury for this logic. He's using simple math. This is courtroom chess, and the defendant is out of moves. Watch how the judge frames it. He's not accusing outright. He's pointing out how the facts speak louder than excuses. That's the brilliance here, and this is a masterclass moment for anyone interested in law. Judges don't need to shout to dismantle a story. They let the inconsistencies do the work. The suspense now builds. Will this end in a bond violation, or will the defense somehow keep him out? Stick around, because Simpson is about to drop the hammer.
Judge, I think we don't need to have a hearing. He could
Okay, let me
confess
ask
to-
you this, because I'm about to revoke his bond. So, do you want a hearing on this, counsel?
Yes.
I figured as much. All right. I'll leave the preliminary exam date. I'll set a hearing. On his bond violation. Can everybody be ready next week? Might be appropriate we do it on Halloween.
Judge, I can't do it on the 31st. Unless we do it, or I guess I could do it right at 1.
Right at 1, yeah. You don't know how my days work.
Oh, I know,
But
I
mean-
know.
This exchange is where the courtroom tension spikes. The defense hesitates when asked about a bond violation hearing. Think about that hesitation. It screams lack of confidence. If your client is clean, you jump at the chance to prove it. Instead, we get a back and forth shuffle until Simpson makes it clear. Bond is on the chopping block. This is the moment where the gavel isn't just symbolic, it's leverage. For defendants, a revoked bond means sitting in jail until the next hearing. For the judge, it's about protecting the community and the victim from repeat boundary pushing. And here's where Simpson shows his cards. He's already leaning toward revocation, and every weak excuse only seals it further. For you watching, do you think bond should have been revoked sooner, or was Simpson fair in giving them this last shot?
Well, we normally set it at 3, but I don't know if that's gonna cut later causes you a problem.
Yes.
So,
I just had something at 10 and 3. So I was like trying to,
there's no way for me to predict what that docket entirely will look like. What about the 7th?
I'm in an assault with intent to murder trial that should be ending at that time. So I think we could schedule it that day. I should be done.
All right, I'll set a bond hearing on his bond for November 7th, 2024 at 3 p.m.
The scheduling here might sound routine, but don't miss the subtext. Judge Simpson sets a hearing for November 7th, but in the meantime, he doesn't leave things hanging. He revokes bond immediately. That's huge. It means the defendant goes straight into custody. No wiggle room, no last-minute freedom. Notice how the defense scrambles, asking for alternatives like GPS tether or a cash bond. Simpson cuts it down flat. This shows judicial balance. Yes, hearings will happen, but immediate safety takes priority. And here's where the case goes from routine to reality. A man loses his freedom on the spot, based on credibility cracks and boundary violations. For the audience, this is the heart of courtroom drama. The human stakes when legal patience runs out.
I'll still leave the exam date in place. All right,
Thank you, Judge. So it'll be here at 3 p.m.
3 p.m.
Thank you.
All right. On that date, at this time, given what the court has heard, defendant's bond at this time is revoked, defendant's remanded.
Judge, can he have some sort of cash bond with maybe a GPS tether just to allow him to continue working? He was living at his job until recently. He had to move when he moved back in the house.
Revoked his bond.
I know.
Okay. No, I understand what you're asking, and I'm going to deny that request at this time.
Okay.
All right.
And there it is. Bond revoked. The defendant's attempt to argue innocent gifts collapses under scrutiny. Judge Simpson made it clear the pattern of behavior, packages, notes, soccer field sightings, added up to repeated disregard for a no-contact order. The lesson? Courts don't just punish violence. They punish persistence when boundaries are drawn. For the children, this is a reminder that custody battles and protective orders are about more than two adults fighting. It's about their stability and safety. For the viewers, it's a window into how fragile credibility can be in court. One shaky explanation, one too many coincidences, and freedom vanishes. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.